With the country observing National Wills Week, Legal Aid South Africa is encouraging people to draft their wills at no cost. The state-owned company is offering their services for free this week to the poor as well as the vulnerable at 128 offices across the country. According to the Master of the High Court, 70% of South Africans don't have valid wills. Dying without this legal document is often the cause of huge problems for many family members left behind. To speak to us a bit more about this initiative and many other related issues, let's bring in the head of Legal Aid South Africa at their Bloemfontein office, and that's Machini Motloung. Thanks very much for your time, Tate Motloung, and welcome to the AM report. It's very easy to start.
Thank you, Ayanda.
Awesome. It's easy to start by asking the obvious question: why do you need a will? We'll get into that in just a moment, but in my intro there, I mentioned that people need to have valid wills. It certainly suggests to me that some wills are better than others. Give us an idea as a start of what makes a good will.
Look, thanks for that very important question. I think what you need to understand is that in terms of the Wills Act 7 of 1953, there are formalities that are stipulated in Section 2 of that Act. Formalities in terms of how a will or what are the requirements for a valid will. One, a valid will should be made by a person who is 16 years or older and who is mentally capacitated to make such a will. Secondly, it should be signed by the testator, that is the person who makes that will, in the presence of two witnesses. And these witnesses must be 14 years or older, and they should be competent to give evidence in a court of law. Now, of importance as well, Ayanda, is that in the event that a person cannot sign a will, the law makes provision for a will to be signed in any other form, such as by making a mark on the will, or by putting a fingerprint on the will. But if that happens, the marking or fingerprint should be done in the presence of a commissioner of oaths, who will then issue a certificate attesting to the identity of the testator who signed that will by way of a mark or a fingerprint. Those are the basic requirements of a will, which would definitely have a bearing on the validity or otherwise of the will.
Yeah. In a context like ours, though, where, in South Africa there are people who can't read and write but have assets, explain to me whether there is a context where someone can express what they want to happen with their real estate after passing on without necessarily writing it down. I'm thinking video wills, audio wills. Does the law make scope for things like that?
Currently in our South African law, we don't have a provision for wills to be made in any other form other than in writing. You'd appreciate that the Wills Act makes actually provision for a will to be in a document. Now, a document, it goes to say that a document would then mean that the will has to either be handwritten or be typed before and thereafter be signed in the manner that I've already alluded to, before that will can be valid. So we don't really, at this moment, the legal position is quite clear that you cannot have a so-called video will or audio will for that matter.
Well, hopefully that's something that can be looked into, because I'm sure you'll appreciate and agree with me that it does have its limitations. But let's speak about then, what can be done in the current context and given these limitations. You've already alluded to the idea that a valid will exists after the age of 16. You'll correct me if I'm wrong there. But there's also a widespread perception that people who have wills are people who have wealth. And so if you don't have wealth, you shouldn't be worried about a will. Is there validity to that perception, or do you think it's a bit misguided?
I think it's a misguided perception, because all that you do as a will, when you make a will, you're actually expressing your wishes in terms of what should happen either to yourself or to whatever your belongings, to your minor children in the event you pass away. Now, you might not necessarily have a bigger estate, but at the same time you will still be having minor children whom should be looked after upon your passing. And you may also be, having certain wishes in terms of how you would want to be buried upon your death. We know of instances where there are, disputes in terms of burial of deceased people, where someone would try and claim the right to bury and also take it to an extent of wanting to bury the deceased at a certain place. Now, if you make a will, you can actually make a provision in your will in terms of how you would want to be buried. So, hence I'm saying it is really a misguided perception that you need a bigger, you need wealth, you need a bigger estate to make a will. You can still make a will without really having a bigger estate.
Interesting. I imagine one of the FAQs to your office, frequently asked questions, is what happens then to the estate of people who don't have wills? Explain to us that process.
Yeah, in the event that, one, you die having made a will which is invalid, which is not in line with the laws, or you die without having made a will at all, your estate will then be administered in terms of the interstate succession laws, where in actual fact, people whom you might not even have been desirous of them benefiting from your estate will benefit. This would be in terms of interstate succession laws. The beneficiaries will actually inherit in line with their blood relations to the deceased. In this instance, if you pass on leaving a spouse and with 2 children, automatically your estate will then be shared or divided amongst the 3 surviving heirs of which would be your spouse as well as your children. Now, it could be that, notwithstanding the fact that you've got such descendants, but it could be that you wanted to also have other people, outside your blood relatives benefiting from the estate, your estate. And unfortunately, in the event of you passing on without leaving a valid will or a will at all, such people will be precluded from even benefiting or inheriting from your estate. So those are actually the challenges that you might be faced with upon your demise or your death, that you would not in a way be able to give out your estate to those that you would have wanted to give.
Right. Speaking about challenges, again, in a South African context, we know there are multiple ways to be dealing with death and what happens thereafter. There's the legal process, which I imagine with the will is quite straightforward, but there's also cultural considerations to be made. People believe there's specific ways through which people's clothes and other assets should be distributed in the event of their passing. How does one reconcile moments where a will and cultural practices actually point to different directions? I imagine you've had to deal with cases like that, especially in a country like ours, where the family believes this needs to happen, but a will speaks about something else.
Indeed. Ultimately, it all boils down to the wishes of the testator. If the testator's wishes are contrary to the practices or the cultural practices, and I think the barometer there is those wishes should not be contra bonis mores, should not be against the morals of society. And if they are not, then those wishes should prevail if they are contained in a document that we call a will, notwithstanding the cultural practices. So your wishes will supersede your cultural practices.
I guess, the perception is that wills will solve all disputes, but clearly we're finding a moment where
Indeed.
not necessarily. All right, we are marking National Wills Week, and that's why we're having this conversation very quickly, because I'm told you're out of time. How do people access your services? I understand this week in particular, people can draft wills with Legal Aid South Africa for free.
Yes, good. Thanks for that question. Yes, indeed. Legal Aid South Africa, countrywide with our 128 offices, employing, legal practitioners with knowledge, skills, and experience in matters of this nature, will be embarking on, assisting clients with free advice in terms of succession and estate planning, but also drafting of basic will at no cost whatsoever to clients. And to this end, it's important to also note that we are in partnership in this period with Blind SA. It's a non-profit organization where we are also assisting, a blind society with regards to make, drafting of these wills. And as Legal Aid SA, if clients would want to access our services, we encourage clients or public members of the public to approach or go to the nearest local offices within their area of jurisdiction. In the event that they are unsure of where the local offices are located, they can contact our legal advice line, which is 0800 110 110, where they would be offered free legal advice and redirected to the closest legal aid office for further assistance.
All right, Machini Motloung, thanks very much for your time. He's the head of Legal Aid South Africa at their Bloemfontein offices. Appreciate your insights into it.